define terms. Any questions? Was this useful discussion? Okay. Ambiguity. All right. There's a chapter in the book called Sources of Uncertainty. In the new edition, it's called Sources of Uncertain Meaning. And a few months ago, I adjusted it after help from my linguist friends. But here's the basic idea. There are different kinds of confusion in contracts. If you want to know how to fix the confusion, you have to be able to identify the kinds of confusion. I wrote this chapter because I've heard lawyers and judges saying it's ambiguous as a way of saying it's confusing. But in fact, ambiguity is just one kind of confusion. It's not just, it's just confusing generally. So if you want to understand confusion, you have to understand the sources. There are different sources. One of them, a big one, is ambiguity. That's where something has two inconsistent meanings. You give a provision to a group of readers, some think it means X, others think it means Y. That provision is ambiguous. Then you have these other kinds of confusion, for example, where you have two conflicting provisions. You can't have both of them working in the contract. Or you just don't address an issue. But the other big source of confusion is vagueness. Vagueness isn't a matter of alternative meanings, it's a matter of uncertain boundaries. A word like promptly is vague. You might do something so fast that there's no question that, hey, everyone will say, you did that promptly. But the more time you take, the greater the chance that at some point someone's going to say, hey, you didn't do that promptly. And because doing something promptly is a matter of what a reasonable person would do in the circumstances, different people can have different ideas of what promptly means. So vagueness involves the possibility of dispute. You can get into a fight over vagueness. So you might think, hey, you said not getting into fights is just a basic idea of contract drafting. Yes, but there are going to be some contexts where it doesn't make sense to be precise, and being vague is going to be your best option. For example, if you have a provision with a limit on legal expenses, but the future holds the possibility of someone suing you because they slip on a banana peel, or you're being involved in some massive environmental contamination litigation, those are very different circumstances. So having a specific amount of money as the limit on legal expenses, no more than $10,000, isn't going to make sense in all those contexts. So you might say, well, this contract is going to address a broad range of possibilities. A specific dollar amount isn't going to work, or a specific amount of whatever currency. So the best thing we can say is reasonable legal expenses. That's a vague standard. You can get into a fight over reasonable, but in this context, it's probably the most sensible thing you can do. So vagueness is an essential tool of the drafter to be used carefully when being precise doesn't make sense.
How about generalization?
Sorry?
Generalization.
Okay. If you want to consider that, you can't generalize. You can't be you have to give me really specific examples.
The contractor has to perform according to the best standards.
Well, you know what? I believe we're going to talk about that sort of thing really soon. So stay tuned in half an hour or so. All right. We'll now look at some kinds of ambiguity. One kind is called lexical, where a word just has alternative possible meanings. The book talks about a fight over what computer means. A video game company had a contract with the developer. Developer agreed not to develop computer games for competitors. The developer went on to develop smartphone games. They got into litigation over whether a smartphone is a computer. That's the thing that, that's what contract disputes are about. That sort of fight. Offshore. An insurance company insured an oil company's offshore oil rigs. An oil rig in the mouth of a river blew up. Oil company says, "May we have our proceeds, please?" Insurance company says, "Hey, we insured your offshore oil rigs." That doesn't mean any oil rig that has water, that's stuck in the water. It means an oil rig that is off the coast of. So they had litigation over the meaning of offshore. So it can require some imagination to spot alternative meanings in words like that don't necessarily occur in contracts every day. But there's one word that occurs in contracts a lot that has this problem: willful. Do you see willful in contracts? Does it mean intentional, or does it mean malicious? In other words, intending to do wrong. Willful has given rise to big lawsuits in the U.S. So willful is on my list of forbidden words and phrases, along with agrees to and agrees that and a whole bunch of other stuff, because it's always asking for confusion. It's discussed in chapter 13 of the book. And depending on which meaning I want, I will express that meaning clearly instead of using willful. One of my consulting clients was involved in the biggest lawsuit over willful. And of course, its contracts are still full of willful. The theory is, we just lost a big lawsuit over willful. Let's check our contracts to make sure we don't have this problem elsewhere. But in a multinational company, that sort of checking is very hard to do. And furthermore, with the power of copy and paste, everything that is old is new again, because you're copying from all over the place, and even if you get rid of willful, suddenly it's back again. So an unhappy contract party will be willing to take any stick that it can use to beat you with, even if it's something that seems really pathetic. Like, there's another kind of ambiguity, is what I call antecedent ambiguity, where you're pointing to something you've mentioned already, but the reader says, "What? What are you talking? This or that? Thereof." The book talks about this fight over thereof. Of what? Of that or of that? Said cost. Said cost, what cost? This cost or that cost, such sums, which sums, those or these? All this is old-fashioned stuff. This is one of those here and there words. We'll talk about here words in a moment. I'll use thereof if it saves me 10 words. If it saves me just a couple, I'll get rid of it because it's too old-fashioned and annoying. But even if I use it, I'll make sure I don't create this problem. And the book talks about said instead of that. Said is very old-fashioned, I'm a lawyer kind of writing. I'd say that costs such instead of that, instead of those here. That's more old-fashioned, very legalistic writing. I'd say those sums. So what this tells me is if you write in the old-fashioned way, you're more likely to create a kind of fog that allows this ambiguity to exist. Even more pathetic is fights over contract reference ambiguity, that's my, basically when the contract refers to itself. Hereunder, fights over hereunder. I'm the world's expert on fights over hereunder. It's not a big field, but hey, I've written about 3 lawsuits in the last few years where people argue over what hereunder means. Does it mean under this section or under the contract as a whole? Or does it mean below this section in the contract? So I don't want to have that kind of fight. So same with herein, in this section or in the contract as a whole. So basically, all the here words are gone. They're on the forbidden list. No hereins, no herunders, none. Except for one exception. What is the one exception? Hereby in language of performance, because that's standard English, and that's useful. And except as provided below in the section, below in the contract as a whole. So no, if I need to refer to a part of the contract, I'll use cross-references with section numbers. Is anyone unhappy with the idea of not using herein anymore? I just say in this agreement. Yeah.
Reference by such a cost or the said cost.
Okay.
I mean, it depends on the. I mean, it's. I can't tell it's a general rule. It depends. Sometimes there is just one cost. So if you said the set cost, it's just one cost.
So you'll have to take my word for it that it is just, it's very old-fashioned. Said is the 18th century version of, 19th century way of saying that cost. So you can always use that instead of said. And your reader will say, thank you. And same with such. Such is good for saying of this kind, of that kind. I like such movies. But using such instead of this, that, these, or those is a bad idea. So it's another habit. But you won't find anyone who will argue about getting rid of said and such, and that use of such. References to time. There's a chapter on references to time. Basically, it breaks it down into different ways that references to time are used in a contract. One is to refer to points in time. Someone at your company or law firm or a client calls up and says, the option expires on 11 September. Do I have time? They're panicking. They want to know, do I have time to exercise the option? The option expires on 11 September. Do I have time? What do you tell them? I think I'd tell them, I don't know. Or it depends. And they say, you're fired. But that's all I can say, because when you refer to a point in time by reference to a day, you're leaving open when in the 24 hours of the day the point in time occurs. I don't want that sort of problem. So I'm going to say, I'm going to give a time of day. In the United States, you see 11:59 p.m. I always think, what happened to that last minute? Where did it go? I prefer saying midnight. But you have to remember that midnight is, you have the last second of one day, the first second of the next day. The boundary between them is midnight. So you have midnight at one end, midnight at the other end. There's a loose convention that midnight 11 September is tonight. But when the deal goes bad and everyone calls their lawyer, you can get into a fight over what midnight means. I don't want that kind of fight, so I'm going to make it clear. Midnight at the end of, at the beginning of. I'm going to make it specific what I'm talking about. And if we're talking about time zones, you can use this sort of reference. Basically, if you have business in different time zones, parties from different time zones, you want to make it clear whose midnight you're talking about. You can say it like this, but I find it easier to just say Riyadh time, New York time, Sao Paulo time, Sydney time, whatever it is. Jones is entitled to 4 weeks of vacation per year. What does year mean? What does year mean? 365 days? All right. But from when?
Employment.
From when? Sorry?
It's the contractual year.
Okay. Well, it's not. I mean, it could be one or the other. The day the contract was signed to the beginning of the corresponding day next year, and following periods, or does it mean? Oh, yeah, don't get me started. Or is it January 1 through the 12 months beginning January 1? If you search for calendar on my blog, you'll find I've done little adventures in Muslim calendar, the Julian calendar, the Gregorian calendar. It can get kind of ridiculous. These days, if you're not specific for international contracts, I think it's going to be assumed that it's are we the Gregorian calendar? I can't remember. But anyway, just the 12 months beginning January 1. But I want to be specific. I don't want confusion as to whether it's the contract year or the 12 months beginning January 1. So I'm going to say it. There's the phrase calendar year. But I don't use that because I've looked at case law about what calendar year means, and most courts say it means the 12 months beginning January 1. But the funny thing about case law is the more case law you have on the meaning of something, the more people have fought about it. So I don't want to win battles. Again, if if it looks like something has caused fights, I'm going to stay away from it. So if I need to say the 12 months beginning January 1, that's what I'll say. If I need to create a defined term year, that's what I'll do. There's a chapter on the part versus the whole. It's the most complicated chapter in the book. It gives me a headache thinking about it. It involves and or, words like and or, each, any, all. The question is whether you're referring to one member of the group or all the members of the group. The level, well, my obsession with it was revealed to me on a flight to Europe a few years ago. A flight attendant approached and said, "Would you like coffee or tea?" And after the flight attendant moved on, I'd been chatting with my neighbor. So I turned to my neighbor and said, I just submitted a lengthy article to a law review that has at the center of the article the question of whether you can answer that exact question by saying both. The conversation stopped abruptly with the neighbor. But it was sad but true. I'm glad I took the old coffee or tea thing out, and I've been very lucky because one of the world's leading linguists, co-author of the Cambridge Grammar of the English Language, a 2,000-page book, kind of took pity on me and helped me with this chapter. So it is now. It's pretty awesome. But the problem is, it's complicated, and no one is born understanding this stuff. So, consider this. Acme shall not dissolve subsidiary A or subsidiary B. Can you tell me in slightly different words what that means? Yes. Yes. Excellent. So, Acme shall dissolve neither A nor B, otherwise known as shall not dissolve A or B or both. Two ways of saying the same thing. You're not dissolving anything. But here's another possible meaning. Don't dissolve A or B.
Both of them is
Dissolve nothing or dissolve both. That's right. And there's a third meaning. You're not dissolving one. We don't care which one, and we don't care what you do with the other. That's the third meaning. And the book actually talks about a fourth meaning. I can only keep three meanings in my head at a time. Which meaning is the intended meaning? I have no idea. That's the thing about ambiguity. It just, these are alternative possible meanings, and no one is born spotting this stuff. It tends to come to light only when the deal goes bad and everyone calls their lawyers. And does this stuff matter? Well, it matters if your contracts matter.
Excuse me.
Yeah.
Sometimes I see they use
And/or. That's that what you're thinking of? And/or. The book talks about it. In the middle of the 20th century, some judges got really, really angry with and/or, and they sort of, it's like you see them shouting in the opinions about this monster of England. I don't get worked up about it. It has a clear enough meaning. A and/or B means A or B or both. But it's always clearer to say A or B or both. So I don't, and the book talks about other complications. Some people misuse and/or. They say Acme shall organize sub in New York and/or Delaware. Well, you can't organize a company in two places at the same time, so it doesn't make sense they say and/or. So I don't start shouting about and/or, but I don't use it. I recommend you not use it. Jones may purchase each vehicle and include it in the row assets. What's the fight about? What's the fight about? You're working on a contract that has this, and the spirit of contract drafting whispers in your ear, fix this or there'll be a fight. What are you going to do?
The option, does it go to the purchase of the vehicle or they include it with the assets?
No, well, that's leaving that aside. That isn't the issue. The issue is, what part of the group are we talking about? The question is, is it Jones may purchase one or more vehicles? Or is it Jones, you buy nothing, or you buy the entire fleet of vehicles? That's your choice. Which does it mean? I don't know. It's one or the other. I won't, okay, so the first thing about this is this stuff is complicated. You only learn to spot it, but you only spot it if you take time to learn about it. Then another problem is that it occurs so much in contracts. And there'll be many places where you have the intended meaning and then you have the unintended meaning. And getting rid of the unintended meaning means adding words. And if you keep doing that, you're going to make a very heavy contract. One example here is, okay, look at this. Sellers complied with all laws applicable to business and acquired assets. That's a statement of fact. The buyer sues the seller for having made an inaccurate statement of fact. The seller says, hey, I didn't say that I complied with all laws applicable to the business and all laws applicable to the acquired assets. Instead, I said that I complied with all laws applicable to both the business and the acquired assets. Do you see the difference between the two? The only way to make it clear, for the buyer to make it clear that the first meaning is intended, is to say all laws applicable to business and all laws applicable to acquired assets. It's longer, more words. And if you do that every time, it's going to get heavy. That isn't the intended meaning.
Would this be the option where you can use?
No, I just not get because it's and/or is just it's just not the clearest option. And the book talks about, this chapter talks about a fight over this or. This is in litigation that went to an appeals court in the U.S. And in the book, I discuss how basically you have to learn to pick your battles in terms of whether you get rid of an unintended meaning of this sort. You can't fix everything. In some of my seminars, I do a drafting exercise, and we look at parts of a model contract, and one thing I show them is one sentence where there are 4 examples of this kind of ambiguity in one sentence of a model contract. So it's all over the place. You can't fix everyone. You have to just find those that are going to create trouble. Basically, what I do now is I learn to spot. I keep my eye out for these kinds of this kind of ambiguity, and I get rid of all the instances of ambiguity unless the alternative, the unintended meaning, is so crazy someone would look stupid arguing for it. So basically, I get rid of only things that can create trouble for me. If something is too crazy, if the unintended meaning is ridiculous, I'll leave it. Anyway, that is the shortest introduction to a complicated topic, because we are now moving on to syntactic ambiguity, another chapter in the book. It's easier than ambiguity of the part versus the whole. It's a question of what part of a sentence a phrase modifies, or what part of a phrase a word modifies. Thing is, it's easier to understand, and you want to get rid of it wherever you see it. But another thing to bear in mind is that it results in far more disputes than any other kind, than ambiguity of the part versus the whole. But before we move on, I'll just give you one little story about and the whole and or thing. Caesars Entertainment is a casino company in the U.S. There's the operating company, parent company. There's a lending document in which the parent company guaranteed the debt of the operating company. But it says that if A, B, and C, the guarantee goes away. At some point, the parent company said, hey, A has happened, so the guarantee goes away. The investors said, A, B, and C. Well, it turns out that A, B, and C doesn't make sense because the nature of A, B, and C is they wouldn't happen together. It's just that they were alternatives. The drafter made a mistake and should have said or. So the parent company said, hey, we're going to say it's or. And of course, the investors have sued, saying you can't just sort of correct it because you want to. It says and, so it's and. So in probably a 200-page contract, what is the fight over? It's over an and. So, these things matter if the contract matters. Back to syntactic ambiguity. Okay. What part of a sentence what part of a sentence does a phrase or word modify? What's the question here? And there are various possible questions, but in terms of syntactic ambiguity, what's the question?
And?
Nope. And is ambiguity the part first?
I mean, it's she may sell the apparel and accessories and.
No, we are. That's you have. It's good that you very quickly become paranoid with the and. So congratulations, you are now ambiguity of the part versus the whole paranoid, like me. But we're not talking. We're moving on to syntactic ambiguity. No, not even.
Store?
Not even. See that? That's right. Okay, that's right. Can you explain that with a microphone, perhaps, if it's on? If-
Basically, are we talking about the children's accessories or footwear?
I think here I'll okay. What is it? What do you?
So basically, it's whether children's applies to accessories and footwear or just apparel.
Okay, yes. The question is, may Acme sell adult accessories and adult footwear? Or is it just for kids? Does children's modify just apparel, or does it also modify accessories and footwear? So if you want to, if the idea is no, you can only sell for children, what's the clearest way of making that meaning be the one? Oh, you could put a colon, the following for children, or a colon, or something like that. I think a simpler, the simpler thing is to just put children's in front of accessories and footwear. If you can sell to adults and you sell accessories and footwear to adults and children, what is a simple way of making that clear? I'm going to put children's apparel at the end, so that apparel is the only thing that it can modify. What's the potential confusion here? But the question is, what's the confusion? You have to tell me alternative meanings, and use the you don't have the microphone. The
It's the same thing here.
You just put excluding Smith assets at the
well, you
end.
have to speak in the.
Okay. You
So
just put-
what are the alternative meanings? That's the question.
Okay. I think you just move excluding Smith assets to
you
the
have
end.
to you have to tell me what the alternative meanings are, because the ambiguity is about alternative
So
meanings.
so the alternative meaning here would be that the excluding Smith assets only applies to Smith assets.
Yes. Okay. Well, that's there. There are the two possible meanings are, selling the row assets and excluding all this stuff, but it could also be selling the row assets, excluding the Smith assets, but you're also selling the Jones and Doe assets. So those are the alternative possible meanings. And you see, using parentheses like this is the way I'd fix it. In the chapter in the book, you have lots of ambiguous examples and then alternative possible meanings that use different techniques to eliminate the ambiguity. So the first challenge is spot this and then use the different techniques to eliminate the ambiguity. All right. This is from a real contract. 5-year term, 5-year renewal terms, unless you give 1 year's notice. What was the fight over? What was the fight over? Again, you're drafting the contract. And if you don't fix it, this is going to lead to years of litigation. Hold on, well, just years of litigation. Any suggestion?
Maybe the exception only for the successive 5 years.
Yes, but again, we're talking about alternative possible meanings. What are the alternative meanings? The fight here was between two Canadian cable companies, Rogers Communications and Bell Alliant. During the first 5 years, Bell Alliant went to Rogers and said, here's our 1-year notice. And Rogers said, no, you don't. That only applies during the renewal periods. So the question is, how far back does this stretch? Does it apply just to the renewal terms, or does it go all the way back? This made for some excitement. This was 10 years ago. One of my readers told me about this. I wrote about it on my blog. Rogers' outside counsel called up and said, would you like to be our expert witness in this matter? I said, let me think for a moment. Yes. I ran around preparing an affidavit. It was submitted. Then New York Times headline: Canada contract, comma, $1 million. It became known as the $1 million comma case. And it said how Adams, a lawyer from Garden City, New York, submitted a 69-page affidavit on how to use commas. And I heard from all sorts of people I hadn't heard from in years, most of them suggesting that perhaps I needed to get a life. But it was exciting. Now, it's a bit of a long story just because the government agency involved said, Bell Alliant, yes, you may terminate during the first 5 years. Why? Because of this comma. And so that's why I had to write about comma use, and basically I submitted my affidavit said, as a matter of how people use commas, this is nonsense. And you can find on my website an article called "Bamboozled by a Comma," because a U.S. court just 3 years ago did this same comma nonsense, and I said it's time for me to try to put an end to this idea that the comma at the beginning of a closing modifier affects the reach of the closing modifier. It's all rather annoying. If you're a fan of commas, check out that article. But the main thing is, so the idea is that some courts have an arbitrary rule that says, if we have a comma there before a closing modifier, that means this, that, or the other. That means that it affects the scope of the closing modifier. It doesn't do much good to complain about courts doing silly things like that. That's not your job. Your job isn't to complain about what courts do. Your job isn't to try and win fights. Your job is to avoid fights. So your job is to spot this kind of ambiguity and eliminate it, instead of complaining about courts using silly games to try and decide what meaning is going to win. The further story here is that this is the best example I know of the problems of translating contracts. Because this started out as a French language contract that said 5-year term, 5-year renewal terms, unless at least 1 year before a renewal kicks in, you say you want out. Once a 5-year term starts, you're stuck. You understand that idea? Whereas here it says, 5-year term, 5-year renewal, but you can get out by giving 1 year notice whenever you want, which doesn't make sense in the context of a term of years. So is a French language contract badly translated into English? So watch out when you're translating contracts.
So you have the first last year of the first 5-year term as your notice period?
No, it's whenever you want. I know that it doesn't make sense, but that's what it says. Okay, so the moral of the story ultimately is learn how to, remember the different kinds of confusion, become familiar with the sources of ambiguity, how to avoid it, and watch out. Let me see. Okay. All I'll point out is there's a chapter on material. Do you use the word material in your contracts? Material breach, and so on. My only point is, there's an entire chapter, but the main point regarding material is that it's vague. It depends on the circumstances, but also it's ambiguous because courts use material to mean a really big, something that's important, a deal breaker change.
Relevant.
Yes, it has to be, but it's really important. But drafters also use it to mean just important enough for me to pay attention to it. So the result is you can have a phrase like material breach that is used in two places in a contract. It's used in a statement of fact where it seems the meaning seems to be, Widgetco, we don't care about your trivial breaches. But in a termination provision, it seems to say, Widgetco, you're not terminating unless it's a deal breaker breach. So two places, one phrase, seemingly two different meanings. So watch out for material. Ask yourself what meaning are you trying to convey. This is one place in the introduction to, well, the preface. I think the preface to the 4th edition. I said I tried to think where I changed a recommendation from the 3rd edition to the 4th edition. I could think of only one thing. The 3rd edition suggests using defined terms for the two possible meanings of material. That's not what I do anymore. What I do, or if I'm not sure I ever did it, what I do now is way simpler. Courts say material is deal breaker importance, so I use material for that meaning. If I mean the other end of the scale for importance, I use non-trivial. So just important enough that it isn't trivial. So those are the two words I use. Material for deal breaker, non-trivial if it's, hey, just important enough for us to pay attention to it.
Did I include the definition for that?
The book, particularly the 4th edition, says, hey, you don't have to, but if it's useful, here's a definition. And it's the same as the definition that's in the 3rd edition.